Unleash the power of knowledge and connect with the heartbeat of the African diaspora. Download our African Diaspora News Channel app now on Google Play and Apple App Store. Stay informed with authentic and diverse perspectives, breaking news, and cultural insights. Immerse yourself in a community that celebrates unity, resilience, and progress. Experience the vibrancy of the diaspora at your fingertips. Don't miss out. Empower your perspective today. Search African Diaspora News Channel and join the conversation.
Today we bring you a breaking story from the legal arena where the state attorney is under scrutiny for its choice of legal representation in a case involving the broad-based Black Economic Empowerment Commission. Let's delve into the details. Hello everyone, my name is Naledi Mfoloe and it is my absolute pleasure to welcome you to the latest edition of the African Diaspora News Channel, where we unravel the stories that shape our world and our communities. Today we dive deep into the currents of information, from the pulse of politics to the heartbeat of entertainment. We've got it all covered, so please stay tuned for a news experience like no other. South African State Attorney Naledi Mfoloe defended the appointment of white lawyers to represent the broad-based Black Economic Empowerment Commission. Now, he argues that their selection was made on their legal experience and expertise rather than race. Now, the Black Economic Empowerment is actually a policy of the South African government which aims to facilitate broader participation in the economy by Black people. Now, this controversy centers around the absence of African Counsel in the legal team representing the commission. Advocate Vuyani Ngalana had this to say.
Just to be clear, at Pabasa we regard this as a briefing patterns issue. It's not a political issue as has been characterized by some. It is a constitutional issue that traces its roots back to Section 174.2 of the Constitution. If you like, I can briefly take you to what Section 174.2, because one looks at what the demographic makeup of the South African judiciary. Section 174.2 of the Constitution, in simple terms, says the need for the judiciary to reflect broadly the race and gender demographics of South Africa needs to be taken into account when appointing judges.
Now, the controversy arose when Gauteng High Court Judge Mandla Nkosi Motwa directed the lawyers involved to address concerns about the absence of African Counsel, suggesting it could potentially violate the Constitution. Advocates Arnold Subel SC and Johnny Klopper SC, representing the Periforum Scaffolding Company, were appointed by the state attorney. Now, Advocate Johan Brand SC, representing the commission, responded to the judge's directive in a memorandum stating that Motwa's comments were totally inappropriate and unbecoming of the office of a judge. Now, leading advocate Tembeka Ngwabaitobi has supported calls for a state-appointed advocate who defied a judge's directive to explain why there were no Black lawyers in the BEE case he was arguing, to face a misconduct investigation. Now, Mfoloe, who emphasized the legal ability and experience of the appointed counsel, Johan Brand SC and Anna Granova, who have 33 and 15 years at the bar respectively, as the primary rationale behind their selection. Now, Mfoloe highlighted the professional credentials over racial profile, asserting that the focus ought to remain on the merits of the legal case at hand and not the racial composition of the legal team.
Where does an independent and competent judiciary come from? It comes from legal practitioners who are competent and independent. And so if you focus the qualitative briefing to one race, you are effectively creating competence in that one race to the exclusion of others. And so those who are not receiving these qualitative briefs are going to be left behind. And when it comes to the appointment of independent and competent judges, the other races that have not been favored with these quality briefs may fall by the wayside.
Now, Advocate Brand SC, representing the Commission, expressed shock and sadness over Judge Motwa's comments. Brand argued that the choice of legal representation had nothing to do with the merits of the case, and clients were actually free to choose their own representatives without being compelled by race. Now, the discussion further delves into a broader conversation about the role of racial representation in the South African legal system. Mfoloe pointed out that in January 2024, the State Attorney's Office predominantly briefed African Counsel for government cases, showcasing their commitment to racial diversity where it is possible. Now, this is a situation that draws attention to the innate tension between advancing social objectives within the framework of the law and respecting the traditional boundaries of legal process and judicial oversight. Now, it also raises vital questions about how South Africa can reconcile the need for a broader representation with the independence of judiciary and the fundamental principles of the legal system. Now, as this legal battle unfolds, questions about the intersection of race, legal ethics, and constitution will undoubtedly take center stage. Now, we will continue to follow this story closely and provide updates as more information becomes available. Please don't forget to like, comment, and share this video. That is it from me till we meet again. It is goodbye for now.